Okay, so I think we'll get started. Okay, so hello everyone, and welcome to this. Sorry, I have a slight problem here. So hello everyone, welcome to this seminar and symposium. Thank you very much on behalf of the Law School and the Human Rights Centre at Essex University for joining us on the first day of this Human Rights and Climate Change Symposium. As an international community, we are of course becoming increasingly aware of the linkages and intersections between human rights and climate change. Those intersections have been there for a long time, but more work is required to understand precisely what they mean in the development of our understanding of human rights, and particularly, of course, how human rights can be used in practical ways in this field. It is impossible, of course, within a symposium of this nature to cover all of the different ways that human rights are engaged with the challenge of climate change. However, we hope that the discussions within these sessions will contribute to the ongoing awareness raising and development taking place within certain specified areas. This symposium would not have been possible without the support and partnership of certain key organizations. So in particular, we would like to extend a special thank you to the Environmental Law Institute in Washington, DC, the University of Beirut, Germany, the University of East Anglia in the UK, the Global Environmental Rights Institute and the Dignity Rights Project, and also Widener University and Delaware Law School, of course, which are linked. We also want to thank in advance all of the experts who are contributing by speaking or chairing in specific sessions. And of course, we also thank colleagues and staff at Essex University who have worked hard to bring this event together. So for all of the sessions, there will be time at the end of the period where the speakers are discussing or giving presentations for questions and answers. So we do ask you to put your questions in the Q&A box at the bottom of your screen. And of course, we do apologize that if not, it's not been possible for all the questions to be answered. Please note that the sessions are being recorded and will be made publicly available on the Essex YouTube channel. Therefore, you can anonymize yourself if you wish in the list of attendees. So at this point, I would now like to hand over to my colleague, Professor Karen Holm from Essex University, who will be chairing the first session. So Karen, over to you.
Thank you, Stephen. And before we start, I want to say a huge thanks actually to Stephen and the whole team, but thanks to Stephen for having this vision, for the immense amount of work it must have taken in the background to get such a fantastic program of talks that we've got over the next few days. So I have the honor to chair this session and to introduce our keynote speaker, Professor James May, or Jimmy, as I understand he prefers to be known. So just a quick bio. Jimmy is a distinguished professor of law, founder of the Global Environmental Rights Institute, and co-founder of the Dignity Rights Project at Widener University. Jimmy is the president and founder of Dignity Rights International and a board member of the Normandy Chair for Peace, the Earth Law Centre, and Delaware Green Watch. He serves as the special representative on harmony with nature for the International Council of Environmental Law and chairs the American Bar Association section on Environment, Energy and Resources Task Force on Environmental Justice. He is also an inductee of the American College of Environmental Lawyers, the Delaware Valley Environmental Inn of Court, the National Judicial College, and Pi Kappa Pi. We all know Jimmy extremely well because he has published very widely in the area of environmental human rights. He has a huge list of books, and he very graciously said that we could name just one or two rather than the huge list that there is. So he particularly wanted me to mention the environmental rights, the development of standards he wrote in 2019 with our own Stephen Turner, And of course, we have to mention the scene-setting, I think, book that was Global Environmental Constitutionalism with CUP in 2015, which provided the first major work in this area of law. He has received numerous awards and recognitions, including from the Sierra Club, American Canoe Association, and Pace University Haub School of Law, and Law Dragon as one of the world's most influential environmental lawyers. Consequently, I can't think of anyone better to open our conference today. And without further ado, Jimmy is going to talk to the topic of, is there a human right to a healthy climate? Oh, just to say so, Jimmy will speak for about 35 minutes. And as Stephen said, please pop your questions in the Q&A and we'll try to answer as many as we can afterwards.
Okay, well, thank you, Karen. First of all, before I get going, just let me know if there's any problem with the audio, but I'll assume we're okay on the audio and visual, Stephen. It's great to see everyone. It's great to have you here. Good morning, good afternoon, good evening. As Karen mentioned, the topic of my talk is about whether there's a human right to a healthy climate. And the answer is contestable. And mine is perhaps that maybe it doesn't matter what the answer is, because I think you should drop everything and pick up every available legal tool to see to it that there is a right to a healthy climate, because there's no time like the present, and we can't wait for the world to catch on or to catch up. But let me thank Essex University and all of the sponsors, and especially Dr. Stephen Turner for arranging this wonderful conference, and Karen for that generous introduction. And just one slight correction is that I'm the co-founder and the co-founder of the Dignity Rights International and the co-author of Global Environmental Constitutionalism with my good friend and colleague, Aaron Daly. So I'd like to make 3 points, if I could. The first is how we got ourselves into this mess, because it's instructive about how to get out of it. The second is to examine how the global legal order has responded to climate change, because that's the most logical place to look for tools. And last, third, is what to do next, what to do now. And this is partially based on Tolstoy's The Three Questions. And if you're not familiar with that, that's a parable about an emperor who seeks a holy person on a mountain for answers he believes will help him be a great leader. And the questions are, first, what's the right time to begin anything? Second, who are the right people to listen to? Third, what is the most important thing to be doing at any given time? So I'll return to these in just about exactly 30 minutes. So the first question, part one, is how we got into this mess. And so forgive me, but some of this helps, again, understand how to get out of it. But we've done it to ourselves. And as far as we know, it's a long journey that led us to the problem that we're in. A very long journey. Life didn't even take hold on Earth until at least 500 million years ago, when bacteria entered the scene as their single-celled microorganisms lacking even so much as a nucleus or a membrane or much of anything at all. Nearly 2 billion more years elapsed before multicellular organisms joined the scene, and most of life has happened over the last 1 billion years. Land fungi came along about 1 billion years ago, and life over the last 500 million years has become increasingly more complex, first slowly, and then insistently and ubiquitously. Arthropods, those are invertebrates with hard exoskeletons well suited for a planet still angry, still roiling and boiling with carbonated atmosphere. They're considered by some to be the planet's first real animals. And then flora and fauna galore happened in geologic terms and flourished, including all sorts of other animals and life forms, fish, forests, amphibians, reptiles, dinosaurs, mammals, birds, flowering plants, bees, cicadas. And as Yuval Noah Harari explains in Sapiens, A Brief History of Humankind, while humans have been around for a mere 4/1000% as long as the Earth has been here. Humans, we took our long time in evolving. Great apes, our evolutionary ancestors, did not appear until 15 million years ago. That's just a blink of an eye. The first human ancestors appeared between 5 and 7 million years ago. The tool-making genus Homo, on the road to being human, that is, emerged in what is now the Great Rift Valley in Kenya about 2.5 million years ago. Diaspora by Homo erectus, that's nearly human, but not there yet. From Africa to modern Asia and Europe started about 2 million years ago. Our population of Homo erectus remained behind in Africa, but then jumped ahead by evolving large brains about 130,000 years ago, leading to Homo sapiens. That is us, you, me. And we started controlling fire about 100,000 years ago. And with it, the urge to burn, to control, began. The last ice age ended 10,000 years ago, concurrent with what many call the dawn of civilization, and with it, the seeds of the Anthropocene. We like to burn things, and we like power. And this is causing what geologists generally agree is the sixth mass extinction, known as the Holocene extinction, or the Anthropocene extinction, as I mentioned, largely caused by human population growth and consumption. So the Earth has experienced 5 great extinctions, that is, evolutionary episodes during which at least 75% of all species disappear from the face of the planet. Most recently, the N Cretaceous Tertiary, known as the KT extinction, which wiped out the dinosaurs. This Anthropocene is the next mass extinction. We're living in it now, and it's caused by human activity, thus Anthropocene. And at present, the rate of extinction of species is estimated to be at least 100 to 1,000 times higher than what might be called the natural background extinction rate, and at least 10 to 100 times faster than the fastest extinction rate that has ever happened. And you'll be hearing more about this cheery biodiversity news soon from Elizabeth Marima and John Knox, and about what this all means for rights of nature later in the conference. But why did this happen, and what can we do about it? Well, the atmosphere consists of 78% nitrogen, 21% carbon dioxide, 21% oxygen, and about 0.9% argon. And no, there won't be a quiz at the end of this, but it puts into sharp relief the role that carbon dioxide plays in the atmosphere. So the remaining 0.1% of the atmosphere, what we're all in now, are trace gases, they're called, trace, small amounts, including carbon dioxide. And from about 150,000 years ago until about the end of the Ice Age and the establishment of the first agrarian communities, the atmospheric concentration of CO2 ranged from about 200 to 250 parts per million. So 1 million parts of things in the atmosphere. Carbon dioxide was about 200 to about 250 parts of those millions of things. It stayed there from the diaspora from the Great Rift Valley and going forward through, well, everything, the Iron Age, Steel Age, civilization and settlement in Mayan, Greek, Roman, Asian, African societies, through the Crusades, the age of exploration, Enlightenment, colonialism and the slave trade, the American, French, and Haitian revolutions, and the American Civil War, and the global depression of the 1890s. And then things started to change. With the Industrial Revolution, the concentration of CO2 started an upward trend that continues to this very, well, right now, this second. It was 260 parts per million by World War I. Which started in 1914, more than 100 years ago. Then, with mass production of automobiles and an increasingly consumptive and mobile society, especially in the West, it was 275 by the beginning of World War II in 1939. Some say the war started in 1933 in China, but we'll go with 1939. And then when Elvis reigned, yes, Elvis Presley, not Costello, it was at the end of the 1950s, it was 310. And then when the Beatles divorced, it was 320. The two weren't associated, but it was at 320 parts per million by 1970. And then 330 during the Iranian hostage crisis in the late 1970s. And 10 years later, it was 340 at the fall of the Berlin Wall in Brandenburg. And then when diplomats negotiated the Convention on Climate Change in 1992, the number stood at around 350. Yes, that's 350.com, that Bill McKibben has been pushing for. Well, 5 years later, at the adoption of the Kyoto Protocol, it was 370. By the 10th anniversary of the Convention on Climate Change, called COP10, and then 15th anniversary and 20th anniversary, it was 390, 400, and 417 parts per million, respectively. And these numbers are far higher than any amount of the known geologic record of atmospheric CO2 loadings over the course, that is, the known geologic record is about 800,000 years. And it just gets worse, right? 2 days ago, the Manoa Observatory in Hawaii measured the atmospheric concentration of CO2 at a level higher than it's ever been, 421.21 parts per million. There hasn't been this much carbon in the atmosphere since at least 4 million years ago. And that, by the way, is with the 6% drop. With the 6% drop in global emissions that are due to the pandemic, in case you were wondering. So consumption is returning to pre-COVID levels, even with COVID. Last year was tied for the warmest record. 14 of the 15 warmest years on record have, 14 last warmest years have been in the last 15, and nearly every year is warmer than the previous one. In 100 years, the mean global temperature has risen from about 13.7 degrees Celsius to about 15.1 degrees Celsius, higher than ever in the geologic record. Again, almost 1 million years of that. We need to decarbonize, or we will be decarbonized. See, the funny thing is global warming is, or was, avoidable. Global warming, and if you don't mind, I'm going to call it that rather than just simply climate change. But global warming is simply thermodynamics. We've known about it, this phenomenon of global warming, for a very long time. In 1860, yes, you heard that right, 1860, before the beginning of the American Civil War, the physicist John Tyndall had theorized and proven the heat-trapping properties of carbon dioxide. By 1890, yes, 1890, in the 19th century, the Swedish physicist Arrhenius predicted that burning coal would cause emissions that would cause global warming. And he won the Nobel Prize. But we had to wait while carbon dioxide continued to accumulate to see this phenomenon happen in science. By the 1940s, scientists with oil companies began to prove it and predict global warming from burning oil and coal, from burning oil and gasoline. And by 1950, Edward Teller, the father of the hydrogen bomb, yeah, that guy, warned about the global warming dangers of burning fossil fuels. And he made his warning, his dire warning, at a keynote address at the annual meeting of the American Petroleum Institute. And for the next 50 years, oil and coal companies, yes, and their lawyers, suppressed, deflected, or destroyed data that showed the inevitability of global warming, including predictions of what's happening now, the Anthropocene. James Hansen and others warned the public at a congressional hearing in 1988 about impending catastrophe in support of national legislation that never happened. But it wasn't until 1992 that the UN adopted the Framework Convention on Climate Change. And it wasn't until 1997 with the Kyoto Protocol that we even allocated reductions, something we're still trying to get right and make enforceable, for example, with the 2015 Paris Accord. We're trying to do that to reduce greenhouse gas emissions to limit global warming to less than 2 degrees Celsius. That's 3.5 degrees plus Fahrenheit. So we've sort of accepted a warmed planet. And more recently, the IPCC has stated a goal of 1.5 degrees Celsius, which we're fast approaching already. We're not making much progress. You see, it's about carbon budgets. The IPCC estimates a global carbon budget of about 500 gigatons. So again, forgive the numbers, but that's basically a benchmark for the budget that we have to contribute more climate warming gases between now and mid-century to meet the goals of the Paris Accord. Now that amounts to about 15 gigatons globally per year. And on a per capita basis, a per person basis, that's about 1.5 tons of carbon per person per year. We're not close. Last year, global emissions were about 36 gigatons. So the effects of climate change, of course, along the way, they're not experienced equally everywhere by all global citizens, of course, raising environmental justice dimensions. We in the United States emit on average 20 tons a year of carbon. The rest of the world, just a fraction of that, about 1/10 of that. Suffice to say that most effects of climate change, though, are more acutely experienced by those living in those who contribute least to the problem, right? Coastal communities, megacities, areas of conflict, drought or flood-prone areas, and by those living through sickness, disease, political or social strife, or poverty, or those migrating, which you'll hear more about later in this conference. This disparate effect is echoed in the Sustainable Development Goals, which are overall to reduce poverty and advance human dignity. And in Pope Francis's encyclica, where Pope Francis wrote, humanity is called to recognize the need for changes in lifestyle, production, and consumption to combat this warming, or at least the human causes that produce or aggravate it. But we're not. So what to do? Which brings me to part 2, which is, do existing legal regimes recognize a right to a healthy climate? So is there a right to a healthy climate anyway? Or as Stephen Turner might phrase it, whether there is a substantive right to a healthy climate. So let's first consider what human rights are. The United Nations Human Rights Office of the High Commissioner defines human rights as those that are inherent to us all, regardless of nationality, gender, national or ethnic origin, color, religion, language, or any other status, and that they range from the most fundamental, the right to life, to those that make life, and this is in the language from the High Commissioner, that make life worth living, such as the rights to food, education, work, health, dignity, and liberty. So does international law consider a right to a healthy climate as one that makes life worth living? In some ways, the answer to this question begins with the establishment of the United Nations itself, going back again to 1945. So the United Nations was established for the purpose, to reaffirm faith, and I'm quoting, to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations large and small. That certainly can bring to mind a healthy climate. And then in 1948, most countries of the world joined the Universal Declaration of Human Rights. Article 1 of the UDHR echoes the UN Charter, and it reads that all human beings are born free and equal in dignity and rights. And the UDHR's 30 articles underscore that everyone has human rights without distinction, presumably including climate status. And then there are the twin human rights covenants. The International Covenant on Civil and Political Rights recognizes things like speech, representation, association, and voting. The International Covenant on Economic, Social, and Cultural Rights does the same for education, healthcare, and family. And both were enacted in the mid-1960s and went into effect in the mid-1970s. And almost every country has joined one or the other. And in addition, many international laws recognize specific human rights, including the Convention on the Elimination of All Forms of Discrimination Against Women, the United Nations Convention on the Rights of the Child, the UN Declaration on Rights of Indigenous Peoples, and the Convention on the Rights of Persons with Disabilities. Yet, as John Knox and Ramin Pejan, whom you'll hear from later, explain in the introduction to their excellent edited book on the right to a healthy environment, none of these specifically address the environment not to mention climate. It isn't part of the UDHR, the Twin Covenants, it being a right to a healthy environment or a right to a healthy climate, or any other international accord that promotes human rights. None of the regional agreements recognize a right to a healthy climate. Even the UN Framework Convention on Climate Change doesn't do so. At best, it has hard-fought perambulatory language that's found in the Paris Accord that had to wait, until 2015. And it reads as follows, that parties should, when taking action to address climate change, respect, promote, and consider their respective obligations on human rights. But should isn't shall, may isn't must. And of course, the benchmarks of the Paris Agreement and the ones preceding it are voluntary and neither recognize a right to a healthy climate nor provide a means to protect it or remedy it or mitigate it. While initially resistant, human rights-based thinking about the environment emerged and the climate is emerging nonetheless. Yet it still largely eats from the children's menu at the table of human rights and doesn't reach the climate. In 1972, things looked like they could have taken a different turn with the United Nations Conference on the Human Environment, or the Stockholm Declaration, it's known as, which declared that man has the fundamental right to freedom, equality, and adequate conditions of life in an environment of quality that permits a life of dignity and well-being. And he bears a solemn responsibility to protect and improve the environment for present and future generations. Again, one can imagine how that could entail and entertain climate justice, but it doesn't. Perhaps the 1989 Hague Declaration comes closest to a right to a healthy climate, acknowledging the right, and I'm quoting, the right to live in dignity in a viable global environment. More recently, the UN Human Rights Commission appointed an independent expert and then a special rapporteur on human rights and the environment, who, as we know very well, John Knox and now David Boyd, have done many things to promote a right to a healthy environment, including agitating for international recognition, issuing framework principles on human rights and the environment, supporting a global pact for the environment, joining judicial workshops on the right to a healthy environment, writing amicus briefs advocating for it, appealing to the United Nations General Assembly and the UN Human Rights Council to establish a resolution recognizing such a right, and arguing that the right to a healthy environment includes climate action. Yet the world still lacks an overarching legal rights treaty concerning climate change that's enforceable. Perhaps additional headway can be made as the 50th anniversary of the Stockholm Conference draws nearer, including efforts to have the UN General Assembly or the UN Human Rights Council issue a resolution or declaration in support of it. There are strong arguments for having the conversation about a right to a healthy environment include a right to a healthy climate and other conversations as well. In 2016, John Knox concluded, and I'm quoting from him, "There is no reason to think that climate change is qualitatively different than other types of environmental harm in this respect, that when human rights organs have examined climate change, they have not hesitated to conclude that it can interfere with human rights." Well, he's right. And to be sure, a 2009 report prepared by the Office of Human Rights at the request of the Human Rights Council describes the adverse effects of climate change on specific rights, including all sorts of human rights to life, food, water, well-being, highest standard of living, dignity, housing, self-determination, and a whole variety of other rights. The Human Rights Council then concluded that climate change-related impacts have a range of implications, both direct and indirect, for the effective enjoyment of human rights. And a number of special rapporteurs have issued reports on the effects of climate change on the rights within their mandates, including on the right to the environment, housing, water, and others. And they've issued joint statements drawing attention to the dangers of climate change. Domestic constitutionalism can play a role in climate conscious lawmaking as well. In her new book, The Ecological Constitution, Professor Linda Collins argues constitutional reform should address climate change. Likewise, in Environmental Constitutionalism in the Anthropocene, noting that the world is in the midst of a global socio-ecological crisis. Louis Coetzee concludes that conventional law not steeped in constitutionality is insufficient to address the modern environmental crisis. Accordingly, constitutional engagement of climate change has made substantial progress of late by the express incorporation of climate change provisions in constitutional text, but there is still far to go. A number of countries, by my count 8, but it can be 9. The Dominican Republic may have been the first to make a constitutional commitment to address climate change in 1998, followed by Venezuela the following year. And in the last decade, we've seen many more instances of countries constitutionalizing climate change. Ecuador amended its constitution in 2008 to adopt comprehensive climate mitigation measures, limit greenhouse gas emissions and deforestation, and promote the use of renewable energy. In 2013, Vietnam amended its constitution to assure that the government takes initiative in prevention and resistance against natural calamities and responses to climate change. Tunisia, which stands to lose up to 1/3 of its land to climate change, entered the canon of climate constitutionalism in 2014, guaranteeing, I quote, the right to participate in the protection of the climate. Sort of beautiful words, right? The preamble to Côte d'Ivoire's 2016 constitution now provides for the government's express commitment to contributing to climate protection. And most recently, Thailand amended its constitution to provide for protection of water resources under threat of climate change. But in addition to climate constitutionalism expressly, there's also good old-fashioned socioeconomic and cultural rights to life, to dignity, and to health that can house climate action and do so effectively. Most countries in their constitutions or otherwise recognize a right to life. More than 160 constitutions recognize a right to dignity. You'll be hearing more about the relationship between dignity and climate change later today on the panel moderated by Erin Daly. Many countries have a right to health. And in the absence of a treaty or a constitutional right, or even legislation, this is where courts have turned to protect the climate, to these socioeconomic and cultural rights. And my point is, so should you, so should we. So that brings me to part 3 as to what to do. Well, given the geomorphology, of climate change, there is certainly work to do. Deep decarbonization, as Professors John Dernbach and Michael Gerard have advocated. Managing our personal carbon budget, as Carl Copeland has advocated. Being everyday environmentalists, as Jason Sarnecki has said. Non-retrogression, as Michel Prière advocates. And deep ecology, as Klaus Bormann has been addressing for decades. But we should do something, right? Naomi Klein, in her book, This Changes Everything, called for mass popular uprising to address climate change. Like in the 1960s, 50s, and 60s, with the civil rights movement in the United States and then elsewhere. Social psychologist Esperin Strokas argues that due to people's natural psychological defenses, however, facts are not likely to lead to change or acceptance, notwithstanding the facts you've heard. Instead, positive stories and collective action are more likely to. So I'm making a case for making some cases. The good stories that will feed the next generation of storytellers, for example, in the Normandy Chair for Peace. So I advocate for putting the law to work now, in any way it can, in any way you can. A global climate rights rebellion. This form of heat advocacy arguably started with the filing of a petition with the Inter-American Commission on Human Rights in December of 2005, a long time ago, on behalf of the Inuit in the United States and Canada, which claimed that US climate change policies violate the rights recognized by the American Convention on Human Rights, which includes a right to life and dignity. So Dean Ariasovsky concludes that with some reflections on the extent to which this kind of advocacy can change the world, that it's worth doing and can be part of much needed progress in protecting the rights of Indigenous peoples and promoting environmental justice as well. So examples, pardon me, of such climate rights rebellion are legion, and they're growing and they're welcoming. Courts and tribunals are increasingly being pressed to consider rights-based climate-based claims in ways you'll hear much more about elsewhere in this conference. In South Africa, for example, in 2016, a court held that even in the absence of an express obligation to consider climate change, the ministry is nonetheless, the government is nonetheless required to consider all the relevant issues, including climate change, and do so before and not after the issuance of a permit for a coal-fired power plant. In Colombia, pardon me, where in 2018, a court issued a landmark decision to protect the Amazon rainforest as a palliative against climate change. In that case, 25 children sought individualized constitutional protection against the government's failure to protect against deforestation. As Maria Antonio Tigre explains in her excellent book on gaps in international environmental law, the case follows the Rio Estrado decision, where the court recognized an ecological constitution. And then in Nigeria, where, in 2006, a court held that the petroleum developer Shell flaring of waste gas in the Niger Delta without the preparation of an environmental impact statement abridged the community plaintiff's constitutionally guaranteed right to dignity and to life. In Norway, challenging opening parts of the Arctic Barents Sea to new oil and gas exploration as violative of a constitutional right to a healthy environment. Ultimately, the claim didn't prevail, but it was worth it. In the Netherlands, in which a court recently ordered the federal government to reduce greenhouse gas emissions and to mitigate the effects of climate change as a means of fulfilling constitutionally and other rights recognized under the European Convention of Human Rights to family health and welfare. In Pakistan, where the Lahore High Court held that the government's failure to develop a climate change plan violates the constitutional right to life and the right to dignity in ordering the establishment of a standing committee on climate change. And more recently, from the Supreme Court, that the government's inaction on climate change violates the right to dignity. From the Philippine Human Rights Commission, which is considering whether carbon majors have violated domestic human rights law. And the Committee on the Rights of the Child, whether the climate crisis is a children's rights crisis, so that mitigating climate change is a human rights imperative, as you'll be hearing more about on Friday. In addition, there are child's rights cases that you're going to be hearing about more in this conference from France, and then just from the last couple of weeks from Germany and Australia. And then in an asylum case, it comes up in curious ways sometimes, this idea of a right to a healthy climate. The United Nations Human Rights Committee recently determined that climate change could become incompatible with the right to life and the right to a life with dignity before the risk is realized. And there are more. These rights-based cases are only illustrative of similar cases in domestic and supranational tribunals worldwide, including before the Inter-American Court of Human Rights in a recent advisory opinion and a contested case, recognizing climate change's disproportionate impact on vulnerable populations. Before the UN Human Rights Council, where last year 5 US Indian tribes submitted a complaint to several special rapporteurs alleging that the US government has violated their human rights in failing to address climate displacement. Before the Inter-American Commission on Human Rights, where earlier this year a petition was filed to protect children in Haiti from environmental harms exacerbated by climate change. You'll hear more about these cases throughout this conference. Then there's one case I'd like to address in particular. Pardon me. Pardon me. One case that shows where this can go, the value of action. And that's using the expression due process under the US Constitution. So there are these oblique notions that due process may form the basis of a constitutional claim to promote a healthy climate. Deprivation of due process can have substantive or procedural dimensions in United States law anyway. And on the substantive side, the leading case is the Juliana case, in which a federal trial court held that 21 children plaintiffs had a legally cognizable cause of action to assert that the US government's collective actions violated the right to a stable climate. under the Due Process Clause of the Fifth Amendment to the US Constitution. So 5 years after it was filed, and just last year, the Ninth Circuit dismissed the case by a 2-to-1 vote, reasoning that even accepting a human right to a healthy climate. So the court accepted there is such a right. And an impending apocalypse, and that's the word the court used. These children did not, nonetheless did not possess constitutional standing to bring the cases, because the remedy they seek should be pursued before the political branches of government, the court reasoned. Aaron Daly and I have contributed amicus briefs on behalf of law professors from around the globe challenging this, and recently published an article in the UCLA Environmental Law Review arguing in favor of constitutional accommodation of a right to a healthy climate. And again, you'll be hearing more about this case from Julia Olson on Friday. And in accepting the constitutionality of the claims, I'd like just to quote from Judge Aiken, the federal judge in the case, who wrote that courts too often have been cautious and overly deferential in the arena of environmental law, and the world has suffered for it. So could I repeat that? Courts too often have been cautious and overly deferential in the arena of environmental law, and the world has suffered for it. Perhaps the same holds for advocates, for activists, for academics, for us. So let us not be like the protagonist in Ian McEwan's book Solar, using our privilege and our power and our positions just to gain a front row seat in watching the world melt. But don't be discouraged, right? When Tony Oposa brought his case against the government to protect wild forests in the Philippines, others laughed at him. His colleagues laughed at him. Judges laughed at him. And that case helped change the world. Most of my advocacy in the climate realm has been in the loss column on issues of standing and political question and preemption and displacement and the Ninth Amendment. But there's still work to do. And at bottom, the lessons to be learned maybe are reflected in the words of Mahatma Gandhi. Be the change you wish to see in the world. So, which brings me back to Tolstoy's 3 questions. How to be this change? First, what is the right time to begin anything? Second, who are the right people to listen to? And third, what is the most important thing to be doing at any given time? The answer to the first question, the hermit in the Tolstoy story said that there is only one time that is important, and that is now. It is the only time when one has any power to act. So act now. File a petition or a lawsuit arguing for a right to a healthy climate. Argue that the right to life includes a right to a healthy climate, or a right to dignity, or a right to health. Do it now. The hermit answered the second question by saying that the most necessary person is the person you're with at a particular moment. So do it for the sake of your children and others' children, and for the sake of humanity, now and for our descendants. The hermit's response to the third question was that the most important thing to do is to do good for the person one is with. And this is because all are sent into the world for that purpose alone. So do good now. Make a right to a healthy climate a reality. Do whatever you can. Do it however you can. Do it wherever you can. Because there is truly no time like the present to advance a right to a healthy climate. And there never will be again this time to do it. Thank you so much for listening in.
Many thanks. That was an extremely interesting and I think inspirational opening to our conference. So many thanks, Jimmy. We have about 5 minutes left and we have no questions at the minute. So if people might start throwing them at us anytime now. But otherwise, Stephen, if you had any questions, we could take our advantage, I guess, now of being on the panel to ask a question. Oh, I'm sure you do. Okay.
Yes, thank you. I was actually intending to dismiss myself, but thank you for the opportunity to come back in there. Yes, I suppose the question I have in relation, Jimmy, you mentioned quite a lot of the different forms of litigation which have taken place and forms of advocacy which have taken place, and with the recent or relatively recent cases that you mentioned, of Lahore in Pakistan, and then the Ahenda case in the Netherlands, and maybe some other cases that have occurred recently in Germany too, some other jurisdictions. Do you think that we are seeing a sort of a tipping point at this moment, or over the last 2 years, in terms of the effectiveness of litigation relating to climate issues, and will that increase the importance and the prevalence of litigation in this area in the coming years?
Stephen, thank you for the question. I don't know that we're at a tipping point yet. In fact, I don't think we're close to a tipping point, but I do think that these cases that you mentioned and the growing number of these cases can get us to that tipping point in time. I mean, what I think should be happening is that all over the world, really what I said I mean, it's all over the world today, there should be legal actions brought to uphold the right to life. That the climate condition is not consistent with the right to life or the right to dignity or health. So we don't even necessarily need a right to a healthy environment to get to that claim, or even international recognition of a right to a healthy climate. So I think that the tools already exist to bring those claims all over in every country and every province and every state and every subnational jurisdiction, and to get to that tipping point, Stephen, so that in 10 years there will be thousands of cases with courts addressing the climate crisis, not just dozens. But these early formative cases are inspirational and help provide a bit of a guiding light as to how to do it.
Thank you very much.
We have a couple of questions. The first one, following on from Stephen's question, really, you may have already answered this to some extent. What do you think characterizes a good lawsuit, so a successful lawsuit? They said they noted that you said the lawsuit in Norway had failed, and why do you think that was?
Well, I don't know. I think, yeah, thank you. It's a great question. What constitutes a good lawsuit? I think a lawsuit does. I think getting into court and getting courts to begin to think about these sorts of issues is a good lawsuit. Every legal claim that's ever been brought had to be brought for the first time, and was probably subject to derision and skepticism and a whole variety of things. And it takes time. In the United States, we didn't even have any First Amendment, freedom of speech jurisprudence until about 120 or some odd years after the First Amendment was adopted. It takes time, it takes courage, and it takes energy to bring these cases. And the case in Norway is an example. It's an extremely important case to enforce Article 112 of the Norwegian Constitution, which guarantees a right to a healthy environment. I think I have that number right. And ultimately, while the highest court in Norway didn't agree that there was an infringement, it helped provide impetus and inspiration for similar claims in other countries. So I think those are good cases.
So Stephen, are we being very strict on the fact that we've met our 2:50 time? We have 2 more questions. I think you want to be strict, don't you, on the fact that you want to have been on time?
I think if Jimmy is happy and if you're happy to answer a couple more questions, that would be absolutely fine with me. Okay. So my colleague Emily Jones, Dr. Emily Jones asks, what potential do you see in a human right to the healthy environment being recognized in the Global Pact for the Environment? What potential do you see in the human right to a healthy environment being recognized in the Global Pact?
Yeah, that's a great question, and it's also separate from the question about a right to a healthy climate. There can be a right to a healthy environment that doesn't necessarily address a right to a healthy climate, and contrariwise, there can be a right to a healthy climate that doesn't necessarily address a right to a healthy environment. But in answering that specific question, I think it remains to be seen. Yeah, I think it remains to be seen. But I think that domestically and regionally, certainly, that there are means and tools available for advancing a right to a healthy environment again now. Uh, and interestingly, those advancements haven't been made under provisions guaranteeing a right to a healthy environment necessarily. There's some examples of that, including the Earth-Life case in South Africa. But for the most part, the protection of a right to a healthy environment has been achieved through enforcement of so-called first-order traditional socioeconomic and cultural rights to life and to dignity and to health. Those are the leading cases. So internationalizing a right to a healthy environment and the role that will play, it certainly can play one. I'd rather live in a world that recognizes the right to a healthy environment than one that doesn't. But legally, what difference it can make remains to be seen. We've understood the climate crisis for a very long time, more than half my lifetime, and we still don't have an enforceable mechanism. So maybe that's a cautionary tale for progress about a right to a healthy environment internationally. I don't know.
And our final one, this is because they recognize that because climate change knows no borders. So is there a mechanism where individuals or states can file cases against corporations or foreign states if there is some international forum, for example, to settle such disputes? So is there a forum or a mechanism?
Well, that still remains to be seen. Not really is the answer. There are the Ruggie principles on human rights issues and business practices. There are claims that can be brought to hold carbon majors to account before the International Court of Justice that some have written about and advocated for. Similar mechanisms are available before regional tribunals like the European Court of Human Rights or the Inter-American Commission or Court of Human Rights and so on, and under the African Charter on Peoples and Human Rights. So at least, that's one place to think about trying to address climate change by, trying to hold those who are in essence responsible to account. In the United States, it's very difficult to do. There are hundreds of cases now that have been brought to address climate change under various claims under the Clean Air Act and under nuisance principles of trespass or nuisance under federal or state law. And by and large, almost every single, or very few of them have even proceeded past the claim stage. And none of them, again, here we are 30 years on, none of them have reached the merits. So, but there's still work to be done there. A lot of it. Now,
could I sneak one last one in? The anonymous attendee asks, why not have an obligation to uphold planetary health rather than an individual-based human right to a healthy environment? So why not have an obligation to uphold planetary health?
Yeah, great question. I think countries should have an obligation to uphold planetary health. So I see this as independent of that. The right that I'm advocating for, it gets down to the human level. So an international accord on a right to a healthy environment or a right or something concerning the climate will address action at the governmental level. And that hardly ever trickles down to people. So that this advocates for a rights-based approach to take climate action that will benefit people, will benefit human beings' rights to life and to dignity and to health and to a healthy climate. So I see, getting back to the question, I see that the two can exist coextensively.
Okay, I think that's our last question. So if we're happy to end the session there, Stephen, did you want to say what is coming later this afternoon? Because I can't find my schedule.
Yes, so we have two more sessions this afternoon. In just over half an hour's time, we will be having an audience which features Elizabeth Mrema, the Executive Secretary of the United Nations Convention of Biodiversity, and Professor John Knox, the former UN Special Rapporteur on Human Rights and the Environment. And that will be a discussion relating to the linkages between biodiversity, climate change, and human rights. And then later on this afternoon, after that, there will be a panel session which is being chaired by Erin Daly, Professor Erin Daly, who is Jimmy May's colleague from Delaware Law School, and that relates to dignity and human rights and its relationship to climate change. So we hope that people will join us for those sessions.
Yeah, and if I could just say thank you again on behalf of all of our attendees, first of all, for such a fantastic opening to the conference and for fielding the questions, obviously, so well as well. So thank you, Professor May.
My pleasure. Thanks, everyone.